Hello, my name is Clark Wilson, and I am an attorney at the law firm Merchant & Gould. I will discuss some basics of trademark law. A trademark is a word, device, or symbol used by an individual or business to identify its goods or services and to distinguish them from others. When a trademark is used in relation to services rather than products, it may sometimes be called a service mark. Trademarks and service marks identify the goods and services as coming from a single source, and consumers rely upon these marks to locate goods and services with which they are familiar. Trademark rights are acquired by using a mark on goods or services in commerce. County or state registration of a corporate or business name does not create trademark rights in that name. The United States is a use-based country, so generally the first person or business to use a trademark is the first to acquire rights to that mark. Under current law, one can file an application to register a mark with the USPTO based on either a bona fide or good faith intent to use the mark in interstate commerce, or actual use of the mark in interstate commerce. State common law protects trademark rights as soon as the mark is used in commerce, but common law protection is generally limited to the geographic area of actual use. State registration of a trademark used in Georgia may be obtained by filing an application with the Secretary of State, and such a registration extends throughout the entire state. After a trademark has been used in interstate commerce, or a bona fide intention to use a mark in interstate commerce is formed, one may file an application with the USPTO. Prior to obtaining federal registration, the designations TM for a trademark and SM for a service mark can be used to indicate a claim of trademark or service mark rights in the mark. The federal registration designation R may be used once the mark is actually registered with the USPTO. The R designation should only be used on goods or services that are the subject of the federal trademark registration. State and federal trademark law allows a trademark owner to stop others from using the same or similar marks for similar or related goods or services where consumers would likely be confused as to the true source of the goods or services. Also, in the case of very famous trademarks, protection can even extend to unrelated goods or services. To avoid conflicts with earlier trademark rights, it is highly recommended to conduct trademark searches, which include searches of the USPTO and various state offices. It may also be advisable to conduct a broader search as well, including databases that contain names of registered companies, and also an internet search to determine if the desired trademark is either already registered as a domain name or otherwise being used. Often, trademark attorneys can order a full clearance search report and review the results to provide a more informed opinion on whether an owner should apply for registration of a particular mark. Even the most exhaustive search will not be conclusive. When selecting a new brand, it may be advisable to contact a trademark attorney to help determine whether a particular trademark is available for commercial use. Words, slogans, and drawings which merely describe characteristics or functions of goods or services are available for all to use and usually cannot be trademarks. The strongest marks are coined, arbitrary terms that have no descriptive meaning with respect to the product or service. Terms that suggest a product or a quality of the product can be protected as trademarks, but these are generally not given as broad of a scope of protection as are arbitrary marks. A trademark is a valuable business asset. Properly adopted, used, and protected, It can last forever. Because selecting and protecting trademarks involve various legal requirements, an attorney familiar with trademark law should be consulted before a mark is first used. Please consult a trademark attorney of your choice for specific information.